The Attorney-General of Australia is the first law officer of the Crown in right of the Commonwealth of Australia, Chief Law Officer of the Commonwealth of Australia and a Minister of State. The Attorney-General is usually a member of the Federal Cabinet, but need not be. Under the Constitution, they are appointed by the Governor-General on the advice of the Prime Minister, and serve at the Governor-General's pleasure. In practice, the Attorney-General is a party politician and their tenure is determined by political factors. By convention, but not constitutional requirement, the Attorney-General is a lawyer by training. It is one of only 4 ministerial positions that has existed since Federation. Since the 20th of December 2017, the Attorney-General has been Christian Porter, a Liberal member of the House of Representatives from Western Australia. The Attorney-General is nearly always a person with legal training, and 11 former Attorneys General have received senior judicial appointments after their ministerial service. Billy Hughes was the longest-serving Attorney General of Australia, serving for 13.5 years over 4 non-consecutive terms. This included 6 years during his own prime ministership. Historically, the Attorney Generalship was seen as a stepping stone to higher office. Alfred Deakin, Billy Hughes, and Robert Mingus all became Prime Minister, while John Latham, H.V. Evatt, and Billy Snedden were leaders of the opposition. Lionel Bowen was Deputy Prime Minister under Bob Hawke in the 1980s. Additionally, 4 former Attorneys General have won appointment to the High Court: Isaac Isaacs, H.B. Higgins, John Latham, Garfield Barwick, and Lionel Murphy. Isaacs later became Governor-General. The Attorney General is the minister responsible for legal affairs, national and public security. The Attorney General also serves as a general legal advisor to the Cabinet, and has carriage of legislation dealing with copyright, human rights and a range of other subjects. They are responsible for the Australian Law Reform Commission and the Australian Commission for Law Enforcement Integrity. Functions of the state and federal attorneys general include the administration of the selection of persons for nomination to judicial posts and the authorizing of prosecutions. In normal circumstances, the prosecutorial powers of the Attorney General are exercised by the Director of Public Prosecutions and staff. However, the Attorney General maintains formal control, including the power to initiate and terminate public prosecutions and take over private prosecutions. Statutory criminal law provides that prosecutions for certain offences require the individual consent of the Attorney General. This is generally for offences whose illegality is of a somewhat controversial nature or where there is perceived to be a significant risk that prosecutions of a political nature may be embarked upon. The Attorney General also generally has the power to issue certificates legally conclusive of certain facts. The facts stated in such certificates must be accepted by the courts and cannot legally be disputed by any parties. The Attorney General also has the power to issue a nolle prosequi with respect to a case, which authoritatively determines that the state does not wish to prosecute the case, so preventing any person from doing so. See Australian Security Intelligence Organisation. The following individuals have been appointed as Attorney General for Australia. Notes: the Australian states each have separate Attorneys General, who are state ministers with similar responsibilities to the federal minister with respect to state law. For Attorneys General of the various states and territories of Australia, see Aus NSW Queensland, South as Victoria wa ACTNT.